Hello, everyone, and welcome to Consumer Watchdog's Rage for Justice Report, our weekly conversation about the current issues we're exposing, confronting, and changing. I'm your host, Carmen Balber, Executive Director of Consumer Watchdog, and my guest today is Alistair McTaggart, the force behind 2018's California Consumer Privacy Act, which gave Californians the strongest privacy rights in the country. And right now, the author of Prop 24, which is on the ballot in November and will set those privacy rights in stone. Welcome to the podcast, Alistair.
Thanks, Carmen. It's a pleasure to be here.
So glad to have you here. So I'll set the stage by explaining the CCPA quickly for those who don't already know that are our listeners. The California Consumer Privacy Act was enacted by the legislature in 2018 only really because you had a sword of Damocles hanging over their head, which was that you had gathered enough signatures to qualify the measure for the 2018 ballot. And so to avoid that, the legislature and the tech industry agreed to make a deal, and they enacted the CCPA as legislation. And we were strong supporters of that. It gives incredible new rights to consumers to know what data companies are collecting about them, tell companies not to sell their data, have the ability to delete the data that companies are collecting about them, to sue company for data breaches, the most wide-ranging privacy rights that have ever been enacted in the country. But of course, there's a problem, and Prop 24 addresses that problem. So maybe we start there, which is, what made you think it was necessary to bring a new privacy measure forward when CCPA just got enacted in 2018?
Well, thanks. It's a pleasure to be here. So when it was enacted in 2018, we did what was called a legislative compromise. We withdrew our ballot measure at the time, and the law was passed unanimously out of both houses. Now, what your listeners may not know, though if they're familiar with Prop 103, they will know, is that initiatives are kind of a separate law than regular legislative law in California. And an initiative generally can't be amended except by another initiative unless the initiative itself tells the legislature that you can amend it. So what we saw in 2019 was repeated attempts by big tech to come after CCPA and weaken it. And I'm not just talking about small things at the edge. We're talking about attempts to remove all data generated by your car, which, by the way, knows everything about you, how much you weigh, where you eat lunch, that kind of thing. To remove all insurance from the law, to remove all behavioral advertising. That's the advertising that tracks you from site to site, from your device to your home to your desktop. So it was not lost on us that, unless we do something here, we're up against the richest, most powerful industry on the planet, basically that the world's ever seen, the first trillion-dollar companies. We need something to prevent this wave of money from just crashing over Sacramento and long-term weakening our law. So that's the main reason is because a new initiative, what it would do is put a floor under privacy, and it would say, hey, legislature, you can do anything you want, make any amendments you want to change, but you can't pass any amendments that hurt consumer privacy. So it would put a floor under privacy.
And well, you're absolutely right that our listeners know well the importance of that kind of protection, because we have been in the middle of a legislative fight to protect Prop 103 from a hostile legislative amendment. Ultimately, those are things that you can knock down in court. If a regulated industry convinces the legislature to pass an amendment that would worsen Californians' privacy rights, then what this measure would do is make that illegal. The courts would overturn it, and Californians' privacy protections would still be in place. And so that is one of the biggest reasons that Consumer Watchdog has endorsed Prop 24, because we know how important it is to protect this law from meddling by the industry. So we're so thrilled that it's going to be on the ballot and give that you're giving consumers a chance to lock those protections into place. But of course, it's not just about locking those protections into place, but expanding the privacy rights that the existing law already enacted. So maybe we can just go through some of the big things that Prop 24 would do to enhance Californians' privacy. And I think in addition to creating a floor for those privacy rights, the top of that list for us is allowing consumers to limit the use of their sensitive information.
Right. This is to me one of the things I'm most excited about in the proposed new law. So the existing law in California today, you have the right to tell businesses, don't sell my information, and to find out what they've collected and to say delete it. But there's an idea in some privacy laws around the world, like all of Europe has this, and this idea is, hey, look, there's some information that's so sensitive that I should be able to tell a business, you just can't use it. So what's that? That's my health information. That's my religion. That's my race or ethnicity. That's my sexual orientation. Some aspects of my financial life. I should be able to say to businesses, look, you don't need to use this. And so think of it this way. Uber can know where I am to get me a car, but they don't need to know my race. And then speaking of where I am, that's almost the one that I think is most resonant with people, is the notion of precise, we call it geo-tracking, geolocation, where these companies are, every time you open an app, every time you look at your phone, they know where you are, like right down to where you're standing. And in some cases, yet as I said, Uber does need to know where you're standing to get you the car. But most of the time that you're looking at your phone, the weather app doesn't need to know exactly where you are. And so we introduced this concept of sort of blurring your location. And what it says is they can't track you more precisely than within a third of a mile. And you say, okay, that doesn't sound very much. Actually, that's 250 acres. So look, they can know that you're a resident of Los Angeles, so they can give you the weather in LA. But they don't need to know you're at the gym or more intimately at a health clinic, at a bar, who you're standing next to. And I, especially when we've done the focus groups, women especially, this notion of being tracked everywhere they go, it resonates with them. This idea of like, I don't like this big brother looking at me all the time and not knowing where that information is going. So this sensitive personal information, the ability to block the use of it is just, I think, one of the best parts of this law.
Well, and location tracking has been the source of a lot of angst over the years when it, becomes more and more obvious that your phone is keeping a record of everywhere you're at, and that information might be available to people you don't want to know. So now that we've also all got apps on our phones that are tracking that information too, it's such a big deal to be able to say, no, don't collect where I am. And, you gave me a really good example of how this data could be used in a horrific way that I think is really important to point out, which is because apps are able to use your precise geolocation, they can then sell that data based on the facility you're at to advertisers. And this has been done to target women at abortion clinics with pro-life advertising while they're sitting in the waiting room at the abortion clinic. And Prop 24 would say you're allowed to say no more. And I think that's just such a critical importance. And, you can come up with a lot of other examples of how advertisers want to know that you're at the bar, want to know that you're at a gay club, want to know where you are so they can target you with information that many of us don't want to see. So I think that's just such a critical protection.
Yeah, absolutely.
So the one of the other big things that the law does is bring us more on par with some of the privacy by design and other ideas that have been implemented in Europe, like data minimization, purpose limitation, storage limits, all of which kind of sound like technical wonky terms, but they're really important to create the kind of privacy rights that assume you're supposed to protect privacy rather than protecting privacy as an afterthought.
Yeah, the way I think about this is, if you think about our own country and our Bill of Rights is pretty loosey-goosey in terms of it says, freedom of speech, freedom of association. Well, what does that mean? Well, we're going to let the courts figure that out, and over time it becomes meaning something. But there's actually immense power in having just the concept stated and then because then the onus is on people to comply with with freedom of speech. So in this situation, what we have is these three really powerful new concepts, which we've actually imported from Europe. One's purpose limitation. Tell us why you're using our information, and then don't use it for different purpose. Storage limitation. Tell me how long you're going to keep my information. Don't keep it longer than you need to, and don't keep it longer than you've told me you're going to. And then data minimization. Okay, why do you need to collect my information? Okay, then don't collect more than you need to do the job that you say you're going to do. So you're on a weather app and they just suck all your contacts or something. And I think these three rights are going to become incredibly powerful over the years because there's so much that comes from that gives the regulator the ability to go back and say, no, you're not allowed to do that. And so I think again, there's so many parts of this law that I'm excited about, but those three I'm really excited about because it'll set the course, so to speak, for privacy in this state, and I think ultimately this country.
Well, and in just extending the comparison to Europe further, if you pay any attention to privacy issues, you know that Europe is leaps and bounds beyond this country, and Prop 24 brings us much closer to the kind of standards that European law, they call the GDPR, enacted for Europeans. So it brings us, puts us into a position where we could actually rival some of the privacy protections that other folks have around the world.
Yeah, and a couple of other ones, the provisions in this law. So it gives you a new right to correct your data. Okay, you have the wrong data about me, now you have to correct it. It gives you the right to object to profiling. So one of the issues that we're all aware of now is, Carmen, you'll see different things on your feed than I will. And the algorithm has typecast you as one way and me as something else. And the question we all have is, well, am I only seeing, for example, certain jobs because of the color of my skin? Or am I only seeing certain opportunities because of whatever you think my education is? And so one of the things this law would do was let you find out what the algorithm, how it's working. Like how is it presenting me the data that I'm seeing? And then it also would let you to object to the automated decision making where you're just being stuck in a slot because of what it says, and good luck with the recourse to saying, well, why did I see this, or why did I not get to see that other job? And I think that also is incredibly powerful in terms of the next century, because as artificial intelligence gets more and more powerful, and as the data that's been collected about us, my kids are going to, every single piece of their life is going to be measured and collected and put in a vault. And so you really got to start to tip the scales back towards giving me some control over what's happening, what I'm seeing.
So one of the things, Alistair, that I have seen in the misinformation that always circulates during a ballot initiative campaign is claims that Prop 24 would expand pay for privacy, making people pay if they want to opt out of the sale of their data. So maybe you can illuminate what Prop 24 really does on that front.
Thank you. Yeah, this is a big misinformation. So the first thing to know about, there is a section in the law that is in the existing law that does allow businesses to take steps if a person opts out of the sale of their information. We don't change that section. So it's the same in existing law to the new law. The opponents are misleadingly calling this pay for privacy. This is part of the original deal in 2018, and really the genesis there is around the news media, which, as we all know, have been suffering so greatly at the hands of sort of Google and Facebook. Basically, if a consumer shows up at a site and says, don't sell my information, the existing law and the new law would allow that site to charge them a fee that's related to the value of their information. It can't be coercive or usurious. But think of it this way: you show up on a newspaper with your ad blocker enabled, and you demand to have the same service as anybody else. That's a quick way for you to put the entire news media out of business, and that there's societal consequences to that. I do think over time this will get refined and business models will change. But one of the problems with doing these things is you have to walk before you run. Now the opponents are basically pointing to this 2018 provision and saying we're doing something terrible and nefarious, but we're not. And in fact, we have a great new way for consumers to, we hope, have no retaliation whatsoever, no charge, and that is that we're introducing a carrot for businesses that are willing to not charge consumers. And the carrot is, okay, business, you don't have to put the Do Not Sell button on your website. And in return, now if a consumer shows up with their Do Not Sell signal, you can't charge them. You can't put a pop-up. You can't put up a cookie wall. You just have to take and treat them like any other consumer. And I think that there'll be a huge incentive over time because businesses aren't going to want to have the Do Not Sell button. So, and over time, it's going to be like the scarlet letter. And so the better businesses will not put up the Do Not Sell button and not charge you at all. So I think that's one of the other innovative parts of this new initiative.
Well, and that's something that we are really looking forward to as a wider adoption of Do Not Track, because when I was working out of our Washington, D.C. office, the Do Not Track button was a hot topic of discussion. Consumer advocates were pressing to define what it means and encourage its use. And the few browsers that at the time enacted Do Not Track as a default on web browsers ultimately turned it off because it was meaningless, because no companies were respecting it. So creating an incentive for companies to honor Do Not Track signals uniformly, I think would be a huge step forward towards real adoption and everyone getting those privacy rights by default.
Right. This area has gotten a tremendous amount of scrutiny and has been very contentious from some people who say in that original legislative compromise, hey, you should never have agreed to let businesses charge you if you, the consumer, opt out of the sale of your information. The problem is really where it came down to is newspapers and the news media, which, as we all know, are having a terrible time right now as the internet is sort of being destroyed by Google and Facebook. In many cases, they exist through advertising, and their business models, some of them have moved to subscriptions, but even they still rely on advertising. And so the notion that you could show up with your ad blocker and not see any ads from a newspaper and then say you demand to see have the same quality of service as anybody else would literally put them out of business. So I personally, over time, hope that this provision gets amended and that over time we get to a world where when you opt out of the sale of your information, it's seamless to you and you can't be charged. But this is sort of like one of those things in life. You have to walk before you run. And so that's why we agreed to that compromise in 2018. I still think it was a good compromise. And yes, the charge has to be related to the value of the information that you sell, and it can't be usurious, unjust, coercive, or unreasonable. But the point for your listeners to understand today is that we don't change that in the new law. That just stays where it is in the new law.
I think we'll close there, Alistair. Thanks so much for joining us on the podcast.
Thank you so much for the opportunity. I really appreciate it. And for any listener out there, please do vote yes on Prop 24. It will make an enormous difference, both short-term and long-term, for this state and for this country. If people want to learn more, they can go to caprivacy.org, and that's caprivacy.org, and you'll find everything you want to know about this initiative there.
Well, thanks for joining us, Alistair, and thanks for listening, everyone. Tell your friends yes on 24 this November, and don't forget to subscribe to the podcast on iTunes, Stitcher, or wherever you get your podcasts. I'm Carmen Balber, and this has been the Rage for Justice Report.